you so much. Thank you for coming, and I'm much looking forward to our conversation. With characteristic concern for the intellectual well-being of you, the audience, the Massachusetts Institute for the Humanities has assembled a blockbuster panel to discuss our topic today, judging judges. What makes a justice a good justice, and more broadly, what makes a judge a good judge? You have their biographies, they're well known to you, and I won't introduce them at length. We have three extraordinarily distinguished scholars, David Greenberg, a presidential historian, Renee Landers, a law professor, and Richard Posner, our most celebrated and prolific federal judge, who is well known for his shy taciturnity and reluctance to express his opinions. My job as moderator is to have no opinions at all, but to encourage a conversation. And unless I'm guilty of moderator malpractice, that should not be a hard thing to do. So let's just plunge right in. Obviously, we can't talk about judging judges before we have a standard for how to judge judges. Judge Posner, you've written a wonderful book on judicial reputation, your Cardozo book, and you seem to use citations as one measure of judicial greatness. But when we look to members of the current Supreme Court, I gather that the most cited is Justice Scalia, although he's not necessarily the most influential in terms of his jurisprudence. Why are citations a good measure of judicial greatness?
They're not necessarily a good measure of greatness. They're a measure of influence. Someone whose work is heavily cited has caught the attention of other people. They may disagree violently, but they feel they have to engage with the person. And of course, Scalia has carved out a distinctive niche for himself, and that has, he has many followers and many opponents, but having defined a clear position, his theory of original interpretation, it becomes a magnet for commentary and disagreement and so on. So that's, like I said, not a measure of greatness, measure of influence. And the influence isn't necessarily that he swings the decisions of other people on the Supreme Court, but he influences how students are taught, how lower court judges think about the problem, how congressional committees, the Senate Judiciary Committee thinks about confirmation criteria. So, yeah, he is deservedly influential.
Professor Landers, what about justice?
I'm sorry, I can barely hear you. My hearing is
Ah.
but way back.
Isn't our
Would you all move to about 3 feet from the edge of the stage?
No, we can certainly speak up. Is that a little better, sir? Very good. Can everyone else hear? Wonderful.
And sir, and if you want to come to the front row here, maybe.
We'll all speak up. My next question is to Professor Landers, and the question is, what about justice as a standard for judging judges and justices? I'm struck by the fact that none of the current members of the Supreme Court today embraces justice as an ideal. From Scalia's originalism that Judge Posner referred to Breyer's pragmatism, it seems like we're all positivists now. We think that it's the law democratically enacted by legislatures that matter. Should a judge be judged by his or her ability to embody basic principles of justice?
I think so, and I think I would take a little bit of issue with the notion that no one on the Supreme Court ascribes to the view that justice is part of their job. I think most recently this term in the case about whether Title VII prohibits retaliation against workers who bring employment discrimination claims. Justice Breyer actually, in an opinion that was part of the case, wrote that the opinion for the court in the case wrote that he was concerned that if there wasn't a pretty stiff rule about retaliation, and an employee could be penalized, either terminated or relieved from their position, suspended for a period of time without pay, even if the pay were repaid to that employee, that it might deter people from bringing employment discrimination claims. And that strikes me as a comment really about the justice of the case, that recognizing, being able to put himself in the place of the worker who is trying to stand up for their own rights in terms of avoiding discriminatory practices in the workplace. And I think that justice really should be, the commitment to justice should be part of the job, although not the only part of the job, not justice without regard for the law, either as enacted by legislatures or by precedents. The other opinion that I think of when I think about this question is a dissent that Thurgood Marshall wrote in a case called the United States against Crass in a number of years ago, which was a case about whether bankruptcy filing fees should be waived, whether people who were indigent and could demonstrate that they couldn't pay the fee should be entitled to waive of the fee. And Justice Marshall wrote in his dissent that the members of the court might disagree about what the Constitution requires, but that they should at least understand the impact of the decision on real people's lives. And I think that's something that we can ask of all judges, that they at least understand the impact of the decisions on people's lives. They're not abstract legal issues that they're deciding. They're not law professors. They are deciding real cases that involve real people.
David Greenberg, you're a scholar of the confirmation process. Do presidents and Congresses know what they're getting when they evaluate justices, and what they say they want really what they actually want?
Well, that's right. I mean, the area that I've sort of looked at in my scholarship has focused on these questions, which changes a lot over time. And I would sort of add that these notions, such as whether justice is a sort of explicit standard that is embraced in a particular justice's jurisprudence, that shifts over time too. During the Warren Court era, perhaps, it would be much more possible to find active statements of justice as part of their conception than perhaps among today's court, and perhaps that will change again in another generation. So a lot of these standards are historically contingent. That doesn't mean they have no basis otherwise, but it does mean that they're products of their own period and culture. And so when we look at what presidents or senators say they want, or the public and the press that's involved in a general debate, what they say they want in a justice, it may well be that there is a lot of politics involved in that, and in that level of public argumentation. I mean, I think if you look at it, if you sort of try to sort of take the clearest measure, most presidents tend to want justices who will, on balance, favor their political ideology, insofar as that can be predicted and guessed. It can't always, and there are many cases of surprises coming up. Eisenhower famously said that the two greatest mistakes of his presidency were both still sitting on the Supreme Court, and Chief Justice Warren and Associate Justice Brennan. And there are other cases of surprises. On balance, though, the surprises are really the exceptions, and that especially if a justice is appointed, in his or her middle years, later in life, you can get a pretty good sense of their track record, where they've been and where they're likely to head. So some of that talk of surprise can also be political. That can be disingenuous. That can be a way of saying, oh, don't worry about Alito or Roberts. Maybe his record's conservative so far, but hey, he may surprise you yet. When we all know pretty well, what's behind the nomination choice and what we're likely, not necessarily going to get, but what we're likely to get.
I'm interested in the question of politicians versus academics on the bench. Judge Posner, you're an extraordinarily distinguished scholar, and you tend to lionize, perhaps unsurprisingly, scholarly judges, Cardozo and Holmes.
No, that's not true.
It's tough to actually ask the question as well.
They weren't academics. Holmes taught at Harvard Law School for 1 year. That was his whole academic career. Cardozo didn't even finish law school. He was a practicing lawyer for 20 years before he became a judge. I think Frankfurter, who was a professor, was actually a very good Supreme Court justice. He came under a cloud for a number of years. But I think as I look back, and as I think about encountering his opinions, he really was very good. But no, I don't hold any particular brief academics, Supreme Court justice. It is a political court. Now, when Professor Lander talking about justice, if I may suggest, I think what you meant was political liberalism, and of course that's one of the flavors in the Supreme Court. So it is a political court, and I think what one wants primarily is people. Like to find someone as smart as Holmes, that would be great, but that's not. They're not available. So
Is that a
in the realistic choices, I think you'd like to have people who are experienced people, who have diverse experience, and have it's remarkable how cloistered the current set of justices are. They have really very limited experience when you compare them to someone like Robert Jackson, Supreme Court Justice in the 40s and early 50s, who'd been Solicitor General of the United States, been Attorney General, was a confidant of President Roosevelt. He was Chief Prosecutor at Nuremberg, as well as being a practicing lawyer. He had never even gone to law school, actually. He was very smart, but he's also very experienced, and it shows in his opinions. And we could use that. So I'll give an example from a few years ago. What I regard one of the dumbest, I'll give an example of what I regard as two extremely dumb Supreme Court decisions. The first is Clinton versus Jones. That's the case in which President Clinton was asking for a temporary immunity from the Paula Jones sexual harassment suit. His argument was he should have immunity until his term of office was over, and then the suit could proceed. That would have been a 2-year delay. And the Supreme Court turned him down unanimously. And what we say is kind of cloistered, sheltered people, what they didn't realize was that to have a sex case against a president was explosive. And all sorts of terrible things could happen, and they did happen, right? Because it was after Clinton was turned down in his bid for immunity that he was deposed by Paula Jones's lawyers and lied, and then everything ensued, right? The impeachment and so on. It was very interesting, but the country didn't really need it. So you'd like justices who are experienced and practical and can see these train wrecks coming and have a kind of suppleness, intellectual suppleness that enables them to deal with a fact-specific case, to distinguish between a sex case against a president and a breach of contract. That's one. The second case is the Hampden case of last June, Hampden versus Rumsfeld, where the Supreme Court held that the military commissions that the Defense Department had set up were unconstitutional. What I regard as really questionable about the decision is not the analysis of the Geneva Conventions, all that stuff, but there was actually no case. Hampden hadn't been prosecuted before a military commission. Nobody had. And you'd think prudence, simple prudence, would counsel the justice to say, well, let's not get into this very troublesome, complicated area about which we know nothing until we have to, because someone is actually convicted by one of these commissions. And then that person would appeal, get into court somehow, and the justice would try to figure out, well, they'd have a transcript of a trial, something concrete to latch onto. So one of the things that's debated in Hampden is, well, what if the government, has evidence that the evidence against the, person picked up in Afghanistan or Iraq or somewhere is classified, secrets we don't want to let out. We don't want to show that to the defendant. And suppose the government instead gave the defendant a summary of the government's information and left out the classified portions. Well, then a court, the Supreme Court, could look at the summary and look at the full evidence and decide the adequacy of the summary. If it was adequate, well, maybe they wouldn't insist that all evidence has to be turned over to a defendant, which would be required in an ordinary criminal trial. So as I said, I'd rather have practical-minded, experienced people look at the cases in their, full concrete particularity, make reasonable judgments. I think that's all we can hope for.
Can I jump in on this point? I mean, here's, I think, a classic case of where historical changes have changed what informs our notion of what makes a great justice, or who should be chosen for the Supreme Court. I think in any era, intelligence, qualifications, a good mind, a good legal record is certainly been important. But it's really only been recently that sort of expertise in the form of, say, with all due respect to the judge, circuit court judgeship, especially the D.C. Circuit Court as this breeding ground. If you look at the great justices of the 20th century, there are many, many who did not come from the D.C. Circuit Court. Black and Warren and Stone and Holmes, and have all kinds. Some have other kinds of legal experience, but it seems to me to be really in the last 30, 40 years that a particular kind of resume that vaunts circuit court experience, that vaunts perhaps experience at the very top law schools for extended periods of time, has become so important. I'm not saying that isn't reasonable for our age, but it is different and perhaps a product of our own. Over the last 100 years, really since the Progressive era, there's been this cultural vaunting of expertise in all kinds of professional realms, medicine, history, and academia, and so on, and that this may be a symptom and part of that as well.
Well, actually, just to interrupt, just to say, that it actually ties into your first point, because the people who've been judges many years have the track record. It's much easier to predict how that person is going to perform as a Supreme Court justice if he or she has written hundreds of opinions. Very different, because a person might have expressed strong views as a politician, even as an academic, and yet finds himself a judge and everything looks different.
Well, and I agree that that's sort of been the trend, and that's the point that I would agree with the judge about, is that I don't think that that's necessarily a favorable trend, because I think that especially on an appellate court, having a diversity of backgrounds and experiences, the whole structure of the enterprise suggests that that's what would be helpful to producing the kinds of decisions that actually are sophisticated and appropriate, that respond to the real world, that can anticipate the real world consequences of what the decision is. I think also, in addition to this, that one of the other problems with the narrowing focus on the Court of Appeals experience and the D.C. Circuit experience is it gets you the inside Washington lawyer as a member of the Supreme Court, which is not certainly representative of any kind of representative experience of the American experience. It's a very unique and, in its own way, narrow experience, and I think that the court would be better off if there were different varieties of experiences and perspectives represented. Finally, I think there's also been this trend, and you see it on some state courts too, that every time there's a very big hue and cry about the need to be tough about criminal justice and criminal law, that it almost becomes impossible for anybody who hasn't been a prosecutor to be nominated for a judicial position. And again, I think that is unduly narrowing the kind of focus and the kind of perspectives that are brought to bear in the judicial function.
All three of you in different ways have embraced some vision of a pragmatic, politically savvy judge as more effective than a pure ivory tower academic. But Judge Posner nevertheless said it would be nice to have someone as smart as Holmes. Would it? How important is intelligence? Some of the worst justices, by current consensus, have been the smartest. William O. Douglas was commonly considered a genius, but was undone by his judicial temperament and was outsmarted by Justice Black, who, although not perhaps as academically smart, was a far better politician. Do we even want brilliant judges?
Well, I mean, you don't want to have just an IQ test as the qualification. Douglas, he was a fascinating figure. He was smart by all accounts, but he was very bored by the Supreme Court. He wanted to be president. I think he would have been an excellent president. He had a shot at it. He had a shot at becoming Roosevelt's vice presidential candidate in 1944. And if that had, instead of Truman, he didn't have a good chance, but he had a kind of outside chance. If he had become vice president, of course he would have become president. I think he would have been an excellent president. A lot of charisma, smart, tough. But you know, I think if you want to be president and you don't become president, the Supreme Court begins to look like pretty small beer. So, and he had money problems with his many wives. You know, he negotiated one of the worst divorce decrees in history because it gave his wife. I've forgotten the details of it. I think it gave her some big claim on future royalties that he earned. So he was constantly strapped for money and bored and busy chasing women and so on. So he didn't perform up to his ability as a Supreme Court justice. But Holmes didn't have these problems, and it's not just that Holmes was really very smart, but you know he was a person of great cultural scope. He had led a sheltered life, except for his Civil War experience. He'd never been involved in government, but he had a great range of reading, and he brought that to bear in his decision. He really added something. You wouldn't want 9 Justice Holmes on the Supreme Court, but one could add a lot. And someone like Brandeis brought to the Supreme Court also very high IQ, but very interesting experiences as a sort of public interest lawyer. And again, Confidant, President Wilson, and so on. So very, very broad interest and experience that made him a real asset, although he wouldn't have wanted to have 9 of him either. So I agree with what Professor Leonard said. You know, it is a political court dealing with political issues, so you want to have diverse perspectives. You want to make sure there are people there who have worldly experience. Well, if you can find some really outstanding intellectual like Holmes, well, that would add something also.
I mean, I would say, I certainly don't think it's fair to, I don't know if you meant to do this in the question, to put Douglas among the worst. I mean, certainly controversial, yes, but I think if you look at these polls of whether it's scholars or lawyers, jurists, you know, Douglas actually still does rank, you know, have a fairly strong and positive reputation. That may be politically influenced itself. And other high IQ judges, you know, even those who have had comings and goings in their reputation, like Frankfurter, who have the high IQ, you know, I don't think we would rank near the bottom. I'm sure there probably are a few really bright bulbs who would go at the bottom because they lacked many of the other requisite qualities of judicial temperament and, you know, some, I mean, after all, it is a body of 9 people that requires negotiations to get opinions in the majority. So do you rate a judge simply because his lone dissent is brilliant, or because he or she writes an opinion that's a little less brilliant but somehow manages to get 4 others to agree with it? You know, I think those are both valid criteria, and they're different kinds of justices.
You mentioned judicial temperament, David, and I want to ask all of you about how important it is and what it is. Chief Justice Roberts recently defined it as a willingness to sublimate your own ideological agenda for the institutional legitimacy of the court, to care more about the institution than about your own program. Is that a good definition, Judge Posner? And does it suggest that judges should be hesitant to express opinions, for example, on extrajudicial matters?
Well, judicial temperament is what Harry Blackmun did not have. So, and I think his problem, just extreme emotionality. If you're highly sensitive to criticism and get very upset when the other judges on your court disagree with you, or when the media attack you, or the professors attack you, and so on. And then when that actually influences how you decide cases, how you write them up, how you resist any challenge to your decisions, That is a very serious problem. So emotionality, or the other side of emotionality, would be detachments. They have to have a certain detachment. You have to understand that people can disagree with you without being evil people, stupid people. I don't know if it goes much beyond that. Of course, Justice Scalia and others are sometimes criticized for temper and for saying things outside of the court setting that are inappropriate. So that's a temperament. Okay. So emotionality on one hand, losing your temper, flying off the rails and so on the one hand. The other kind of detachment, so you maintain perspective.
You know, I think, you know, as somebody who sits on the Commission on Judicial Conduct in Massachusetts, I think that not having, you know, what we might all agree, even if we can't put the words around it, a judicial temperament, is actually very undermining of effectiveness on the bench. I think for two reasons. One, in the respect that Judge Posner was talking about, but also if you think of trial judges, you know, their behavior in the courtroom, in the courthouse, when they're not even sitting on cases, does a lot to impress litigants and lawyers with the sense that the judge is in control of his or her own feelings and relationships with the world, and is therefore able to make decisions that are about the case and are not about the judge's own view or the judge's own you know, emotional baggage or other kind of baggage that they're carrying into a particular case. And I think that that without that the public has no sense that there or confidence in the legitimacy, the credibility of the decisions the judge is making. If there's, you know, all kinds of you know, emotionalism or rude behavior that surrounds the actual decision of the case. I think also that, you know, you know, Justice Scalia has come up from time to time. I actually do think it's troublesome, the tone of some of his opinions. I think that I find it difficult to imagine what it must be like being in the conference the next time, talking about the next case, when you've been on the receiving end of some of those barbs, or the litigants have. And I think that I just think that he can make the points, that, you know, some of the legitimate points that he's trying to make without you know, being personally insulting and you know, questioning the intellectual capacities of people who might disagree.
David, do historians even care about temperament, or do they just care about which judges accurately predict issues that the future generations come to care intensely about?
Well, I mean, I think in some ways they do go together, because, I mean, I'm just thinking about Scalia. I think it was probably Scalia's temperament, so far as we can describe, you know, these perceived shortcomings of his as part of that rubric, that cost him the Chief Justiceship. I mean, I don't know for sure what was in the deliberations, but it seems to me that had he been a more, you know, restrained justice in his temperament, in his manner, the way he wrote his opinions, the way he, you know, and actually by many accounts he's quite cordial and civil to his fellow justices in person. But nonetheless, this public image for justices is important too. And, you know, if that cost him the Chief Justiceship, well, that too then can cost him his legacy in the long term. That is, certainly not all, but most Chief Justices are written about more, cared about more, thought about more by historians because of the way they guide the court. So although it may be the outcomes that justices produce, those outcomes are a product of qualities other than sheer, you know, brain power and legal reasoning power.
I don't agree. Rehnquist, I think, was more influential in the 70s than when he became a Chief Justice. And I think for someone like Justice Scalia, it's a trade-off. He can be defining an agenda by the vigor with which he advances his views. That's one career path. Or he can be a nice pussycat and become Chief Justice and preside in a dignified fashion. But it's not obvious that second career path gives a person more of an impact.
Can I say one other thing? We've been talking about this from the point of a very careerist perspective, that one, works and, advances in order to become at the end of the career, at the pinnacle of the profession as a Supreme Court justice. And I'm now here, I'm treading in your territory as the historian, and I'm not saying that people weren't careerist in the past, because I don't have, I'm not quite that influenced by the good old days, or some characterization of the good old days, but it does seem to me that in former times, the judicial calling was seen at some level as more of a public service kind of calling, and not the sort of the pinnacle of a career that one would work to achieve. And I'm obviously painting with a broad brush here, because you have, situations of people, having, being in the Senate, and President of the United States, going on to the Supreme Court, and so that without it seeming as if they were taking a step down somehow by, undertaking this other job that required them to really work again. And so I think that, I think it would be good if we could talk about these positions a little bit more in that way, instead of just in this kind of careerist fashion.
Well, I think that's true, although, I was just thinking of Charles Evans Hughes, who had been many things, including a Republican Party nominee for president in 1916. Hughes was on the court, left the court, and then came back, was reappointed again, and faced a lot of skepticism at that moment about, well, why do you leave the court in the first place? And I think there was a kind of, if not explicit, sort of implicit question of careerism involved there. That, oh, well, now he has the great brass ring of the Chief Justiceship dangled before him. This was held out.
We've had a couple of examples of the anti-type of a successful judicial temperament. Judge Posner said Blackmun's emotionalism is a bad thing. Several of you suggested that Justice Scalia's bullying temperament might have alienated his colleagues. What's the prototype of a successful temperament? Chief Justice Marshall is often cited. He was loved by his colleagues. Story gushed about it. He said, I'm in love with his temperament, positively in love. He was supposed to be congenial. He drank Madeira with everyone. He ran faster than all of the other people at Valley Forge. How important is it to be a nice guy?
I think it counts for a lot. It's funny, I was sort of looking at different definitions of judicial temperament and so on, and some of them are so broad, including compassion and sensitivity and open-mindedness and lack of pomposity, which, I don't know how many meet that test, but, and I was going to say, includes everything except the ability to run, a really fast 40-yard dash, but now you've sort of ruled out that one as well.
And Justice Breyer had to go jogging with the president.
Right, exactly. So athletic ability, maybe that counts too. It's sort of well-roundedness. But I do think, again, there's different kinds of it, but you look at someone like Brennan, Associate Justice Brennan, who was known, his particular talent was for cobbling together majority positions through a kind of warmth and cajoling, and that is often among. People are reluctant to put it explicitly up front as a criterion because it seems like we're going to make it a popularity contest. But in terms of effectiveness, it's certainly got to rank high.
You scoffed, Judge Posner. Have you ever warmly cajoled your colleagues?
Oh, sure. When I was chief judge, I told the other judges if there's ever a situation where you're on a panel and maybe a dissenting judge has said something really wounding to you, you tell me, and I will speak to that person. I will say, you're going to have to change your opinion because you've upset this person, and you can make your point without doing that. And it's extremely important that the judges be collegial. So, and that was in fact my priority as chief judge, because once the judges start feuding with each other, it makes the court impossible. There's a famous book, Learned Hand's Court, by Marvin Schick, which he talks about the extraordinary feud between Jerome Frank and Charles Clark in the 40s and early 50s. It was childish and vicious, and it simply undermined the work of the court. So there's no downside to being nice with your colleagues and avoiding brutal criticisms. I don't think there's any downside to that. That's a somewhat different, that ought to be easy for people, just to be collegial. I mean, but of course, we have a, short fused temper, be able to do that. What Professor Greenberg said about cobbling majorities together, that's a slightly different thing. It's certainly going to be more difficult if you have a difficult personality, but there's a difference between simply being collegial and being friendly with your colleagues and not saying wounding things to them either privately or publicly. But it's another thing to be able to find common ground if you have judges or justices who are in maybe broad agreement or general agreement or partial agreement. The question is, can you somehow find enough common ground to write a respectable opinion? That's more of an intellectual skill, but it's aided by being collegial. I mean, if you respect your colleagues, then when you disagree with them, you may say to yourself, well, I think he's wrong, but he could be right, since I'm not that confident. Would make it easier to compromise. One of the problems with conventional legal reasoning, which I regard as largely nonsense, is that it convinces judges that they really have the kind of keys to the knowledge of the universe, so that if they come down on some side of the case and say this is right, they really think, it's like 2 + 2 = 4. They know it's correct because they've reasoned to it using some rigorous method that resembles logic or scientific experimentation. The judges who are more tentative about legal reasoning, I think will find it easier actually to compromise, because they'll realize there's tremendous uncertainty and you rarely can be highly confident that you're right, and therefore someone else whom you respect has a different view. Well, that person may be right, that'll make it easier for you to come together with.
Well, I think that it suggests one of the other important qualities is this sort of intellectual honesty and intellectual humility about the task at hand. Because if you could have some 2 + 2 formula that told you what the right outcome was for the cases, you could get the Google people to write an algorithm, and we wouldn't have to have human beings engaged in this activity. So by definition, most of these cases, or many of them anyway, are cases that there's, there are important arguments that could lead to different conclusions and different resolutions of the matter, and to pretend that there's a right answer intellectually divined, by some force of logic is just not correct. But it's different. It's one thing to say that a person is collegial and can get along and be persuasive with their colleagues, and that's not the same as saying that they're a pushover, that they have no ability to argue and persuade from their own point of view, and to, once they've decided that something is right, to actually have some confidence in their decision. And they're not, being nice and collegial is not the same as being a pushover and ineffectual.
I want to ask just one more question before we turn to the audience, and that involves the question of judicial exposure. This is an unbuttoned age of reality TV shows. The justices and judges have by and large resisted the relentless public pressures to reveal details of their personal life, but the norms are changing. Judge Posner, I know you've thought about this. Should judges write memoirs? Should they have blogs?
Well, I think there's actually too much secretiveness about judges. Of course, secrecy, mystique, and so forth, that's power. So the judges want to hide behind their robes and so on, and they want to present a facade of impersonal, rigorous justice. But I don't know what the public interest is in deceiving people about the actual character of judges. So I think the memoirs, the exposés, the Brethren, the Lazarus book, and so on, they have weaknesses and so on. Well, that gives people a more realistic picture of the judiciary. I think that's fine.
I would largely agree. I mean, I do think there comes a point at which if a justice or a judge is out there so much, giving political speeches, doing fundraisers, I mean, there are not only ethical lines, but lines at which the public will cease to have confidence in the impartiality and in the judicial temperament, the open-mindedness, the intellectual humility, the fact that you can go before this justice and get a fair hearing, that if that starts to be widely doubted or even substantially doubted, then I would say it's gone too far. But we're certainly in an age, as you suggest, where in the political realm we have this kind of populistic style where, presidents when they campaign half the time don't wear suits and ties, they wear sweaters, and they're in recreational settings, and the idea is to seem just as much like an ordinary citizen as possible. And the flip side is that if you're seen as too much of an elite, as an expert, as an ivory tower justice, that could be bad for your reputation too. So there is a way in which justices, like politicians, do want to have a little bit of a sensitivity to not being seen as too detached, too far removed from, to go back to Professor Lander's point, to everyday experiences of regular people.
Well, and I think the important thing for the judge is to recognize, that they have perspectives, that their life experience influences the way they think about the cases that they're asked to decide. And because I think for the judge, pretending that you don't have a perspective and that you don't bring these influences to the decision-making, leads, is self-delusional, because, and leads to you to conclude that you're being more objective or whatever than any human being can possibly be. So I tend to agree with what Professor Greenberg has said, that judges do need to show a human face. I think it's very hard, actually, in states right now to be appointed or elected judges without showing some kind of human face. But at the same time, the judge has to, recognize that they need to account for that when they're thinking about making decisions.
Wonderful. Well, with that unexpected note of agreement about the virtues of judicial exposure, let me ask, dear audience, for your probing but judicious questions. Yes, sir.
Professor Landers and Judge Posner just observed that judging is not formulaic. In light of that, what practical guidance, if any, can a good justice find in the oft-repeated statement that judges should only apply the law and not make it?
Well, it just is false. Because in the interesting cases, they're making it up, right? I mean, this is what Professor Lander was saying. If it was just an application, you could probably design some artificial intelligence program that would decide cases. But especially thinking about constitutional cases, most of the Constitution, 18th century document, did not anticipate 21st century problems. And the Supreme Court decides cases, and sometimes what it says casts light on a novel issue, often not. So in a significant percentage of the Supreme Court's cases, but even a pretty large percentage of intermediate court cases, like my case, you really do have to create a new rule without much guidance from the sort of orthodox legal materials, the orthodox texts and precedents. Yeah, that's the reality of American judging.
Well, I clerked for the former Chief Justice of the Massachusetts Supreme Judicial Court, who wrote a book after he retired called Judges Making Law. And I think that says it all. It's just a recognition that it's a part of the lawmaking, the judiciary is part of the lawmaking process in the country. And it's really a whole big, elaborate conversation. There's the Constitution, the Congress has a role, the President has his role as well, and then the courts are just part of that conversation, and all the branches in the public are taking part in making adjustments as we go along.
Let me add an unexpected note of dissent on this, or at least qualification. I mean, there clearly are ways in which the judge's role, the justice's role, differs from the legislators. And Justice Stevens, about a year and a half ago, gave the talk that got some attention, where he tried to point this out under sort of the general climate of imputation that the Supreme Court is wholly political. And he talked about the California medical marijuana case, where he said, you know, my reading of the law obliges me to a different outcome than I might like as a person. And, you know, Justice O'Connor, you know, gave a talk where she prefaced it, were I a legislator, you know, I would have voted to do thus and such, but as a justice, my reading of the law and the Constitution and the case leads me to a different direction. So there clearly are ways in which making law as a legislator, it may be, yes, justices make law, but we mean that making law in a somewhat significantly different sense of the term than when we talk about legislators do it.
No, but that's only part of it, because in many respects, the Supreme Court justices are more freewheeling legislators than members of Congress are. Members of Congress have to stand for re-election. Justices don't. So justices enact laws, don't call it that, but they enact laws that could never get through Congress, right?
I think that's probably true, but I think
So in some respects, they're more unbuttoned lawmakers, and in some respects, more buttoned. But whether they're unbalanced, they're less political or less legislative than Congress, I don't know.
When you seek
Dubious
to
about
understand
that.
their decision-making process and what criteria guide them and what motivations move them, I would think for the most part they are thinking differently from the way they would try to think if they were
As a
legislators.
historian, you should not be giving that much weight to self-serving statements by people as to what their motives are.
It's
Why would a historian?
not. On the contrary.
Look, if you're a Supreme Court justice, you're assailed with charges that you're usurpative, you're undemocratic. So what do? You point to some unimportant case and say, well, as a legislator, you know, medical marijuana, fine, and this is fine, and that's fine, but I'm constrained, and therefore I voted against my preferences. Well, big deal, right? They vote against their preferences in cases that they don't care about.
Well, I'm not sure that that's true, because I actually think there
I
was a
think
big...
it's 100%,
I
but
think-
it's 95%.
I think there was a bigger issue lurking in the medical marijuana case than just, you know, whether medical marijuana should be, should be permissible, and whether the Controlled Substances Act prohibited it. I think what they were worried about in that case is if they said the answer was the other way, what were they doing to hundreds, perhaps thousands of other federal statutes that they had no idea what the consequences of that decision would be in that narrow context? I think they were afraid to
Well,
take
that
that
didn't
step.
stop them, you know, in the Booker case,
Right.
where they, by invalidating the sort of mandatory feature of the federal sentencing guidelines, they undid literally thousands of criminal sentencing, so causing tremendous turmoil, right? They're usually.
But there's a process for dealing with that. There's not a clear process for dealing with the other kind of dislocation that the
But if you
Gonzales
think of what the
case
Supreme
had.
Court has done over, taking the last 50 years, what really has the bit between its teeth, it's caused plenty of turmoil.
Oh, absolutely.
Right?
I mean,
If
Brown
they
versus
feel
Board of
strongly,
Education, right?
If they feel strongly, they'll do something. Well, they didn't anticipate that.
Well, they may, I don't know how they, well, anyway, I think that's sort of the classic example. We could all, maybe all of us would sit here now and say that was absolutely the right thing for them to have done, even though Congress would never have passed a statute that would have required any of the same things at the time. But at the time, it was
And
incredibly
their
controversial. It
internal
made law.
conception of their roles is important along with sort of the outcome of this. So that it may seem to us, well, it doesn't matter what they're really thinking or what justifications they give. Sort of what matters is how they rule. But in fact, having a sense of confidence that the decision-making process is one that is, constrained by law and precedent is I think,
No,
very
I
significant.
think it's the opposite. I think if a Supreme Court justice thinks that he or she is just applying the law, then any crazy result, person said, well, don't blame me, it's the law. Whereas I think a judge who realizes he's exercising discretionary authority will feel more responsible for the consequences. I chose this, not in 1787. This was laid down, and all I do is, genuflect to the framers.
Sir, that was a successful question. Let's have another one. Ma'am.
During your discussion of judicial exposure, I was waiting for one of you to opine on cameras in the Supreme Court.
Well, I think it's a good idea. I don't, see the harm coming. I mean, as it is, we're now getting audio very quickly thereafter of oral arguments and so on. And I just think it is something of an anachronism. I mean, after all, look, we brought cameras into Congress. That hasn't hurt.
Well, I don't know, you see those people. There's a security issue about the cameras in the court. The judges and justices do not want to be recognized in the street, right? So, the Supreme Court justices can still travel, anonymously, recognized by very few people. And I'm sure they value that. So that I think would be the only real objection to cameras.
That assumes that people would be watching.
So that if people
Right.
watch, you worry about, you have 300 million people in the United States, some millions of whom are mentally unbalanced, and preoccupied with this particular Supreme Court justice becomes an obsession of this person, and then you have kind of John Lennon type attack. So, people, I think these people want to avoid celebrity status, because that's dangerous. And real celebrities in our society have to be surrounded by armed guards.
Yes, sir.
In light of what you just said, can you talk a little bit about your views on justices or nominees to the Supreme Court not answering substantive law questions in the nomination process before Congress?
Well, they have to not answer them because it's a terrible trap, right? Because if they answer the question, they immediately lose all the senators who disagree. And if it's a hot question, then the senators who disagree with the answer may be under pressure to launch a filibuster or something. So that they simply, a terrible trap for them. They have been somewhat willing to discuss their judicial philosophies, which is, I think, as close as you can get to learning anything about them.
I actually think they could answer some more questions than they do without having this sort of, totally negative reaction and response from people who disagree. For example, I think it would have been fine to ask some of these recent nominees, if they had been on the court when Brown versus Board of Education were decided this. I know I'm beating this dead horse, but it's that what would you have done? Because it was a step outside the legal mainstream. It was completely changing the law at that point in time. And why? How would you have seen it? And I think you might have been able to get some illuminating answers. I think it would also be fair to ask them, what is their conception, just to take an issue for today's law, of the Commerce Clause, and have them talk about it in broad swaths. What does the Commerce Clause mean for federalism and that sort of thing, and to get some of their thoughts about these broad legal principles that are embedded in the Constitution and that come up in the cases without asking them, how would you decide, a case about, whether, out-of-state wine shipments should be permitted. I think that's a whole different level of question.
Well, I'm actually going to go farther, and I think it's sort of become ridiculous, the way they avoid these questions. I mean, I think about Clarence Thomas sort of saying how he didn't have an opinion on abortion, Roe v. Wade. Probably the only person in America who didn't have such an opinion was now being nominated for the Supreme Court. I mean, I agree with Judge Posner that the rules of the game as they've evolved have made this into a trap. So politically, and in terms of getting confirmed, they're in a no-win situation. I agree entirely. And yet, it seems that if these confirmation hearings are to continue to occur and be seen on television, if they're going to have some value, you know, it should be presumed, or presumed after an initial statement, that the nominee, once on the court, will operate with an open mind and hear the you know, arguments in the case, and not be so dogmatic as to you know, decide before, you know, years in advance how he or she will rule. But it also is helpful to know what they've thought about even recent cases, not just ones where, you know, they're so far in the past and we have such a consensus around the justice behind, you know, desegregation of schools that it's an easy one to answer, but ones that are hard to answer, and to see how they try to wrestle with the different constitutional issues. I mean, you know, going along with the line that, you know, we could have an algorithm to tell us how to rule on these cases. That's especially true at the Supreme Court, that the cases that come to the Supreme Court are the ones that are the hardest to settle, because the easier ones can get settled lower on the chain. So we want to see potential justices wrestling with and giving some indication of how they're going to arbitrate between conflicting legitimate arguments.
Yes, sir.
An allusion was made earlier to the difference between Justice Rehnquist and Chief Justice Rehnquist. And I wondered, what are the attributes that would be necessary or undesirable in a Chief Justice that may not really come to play too much for a city justice?
Well, I think the Chief Justice has...
Forgive me.
Sorry.
The question was, what are the differences in qualities between a Chief Justice and an Associate Justice that make for success?
Well, I would say that the Chief Justice has an institutional responsibility, and if the court is too fragmented, and he is going to be blamed, so he will have to, you know, try to be a good mediator. If he finds himself consistently in dissent, people will say, well, he's lost control of the court. Now, he doesn't have control, but if you don't have control, if you're perceived as losing control, you look bad. And that would tend to make the Chief Justice, you know, try to draw in his fangs a little bit. So they tend to be less divisive, less contentious than as justices, and that can actually be a loss if they had a very interesting, distinctive perspective, which then becomes muffled because they've become Chief Justice.
Yes, sir.
Some years ago, Justice Scalia went duck hunting with Vice President Cheney at a time when there was a case working its way through the federal courts about the Vice President's withholding information about his energy task force from the public. Aside from the danger of being shot, Justice Scalia to have done.
Well, I actually was, it was during my semester on first year constitutional law when that all happened. Justice Scalia issued his 21-page memorandum explaining why it was not problematic, that he was going to still sit on the case when he had gone duck hunting with the vice president. And the first year law students in my class sort of thought, you know, we think he doth protest too much. You know, why did it take 21 pages to explain why it was the right thing to do? And this is a class, I would say it was a class that wasn't, politically liberal by any stretch of the imagination. So it certainly had the appearance of being problematic, even if in fact one could conclude that it wasn't. But it does raise this issue about how much of a real person can the members of the Supreme Court be. Can they have friends in Washington whose agencies or branches of government might have litigation before them? And I hesitate to say that the answer to that question should be a flat-out no, because you don't want them, kind of cabined off without any kinds of connections to the world in which they're, issuing their decisions.
But again, that's a question too that is very variable, throughout history. I mean, for much of our national history, A lot of justices have palled around, been very close with presidents and other administration officials, have served in administration, have left the bench to become a cabinet officer, or these kinds of things. And that it's fairly recently that our ethical strictures have sort of set down this expectation that something like what Scalia did is wrong, as I think it's safe to say most people, not everyone, but most people saw it as wrong. Again, I'm not disagreeing with that judgment, but it's definitely one that's a product of the ethical strictures of our own time.
Yeah, I think what Professor Greenberg says is important. So what's happened in the United States, indeed all of the world, there's less trust in authority than there used to be. So the mere fact that a high official like Scalia says that, of course, he wouldn't be influenced by gratitude to Vice President Cheney for inviting him on this exciting duck hunting expedition. Not quail hunting. That's the dangerous. See, that is no longer automatically believed. Say, if we trusted our officials and if they said, no, I separate the personal and the professional and so on, then it would be very different. But I say we don't have that. So once you recognize that officials are not trusted, they have to modify their behavior accordingly. If they want to be respected as much as possible, they may actually have to sever relationships and pass up nice trips and so on. So that just becomes a cost of officialdom.
Yes, ma'am.
Hi. There seems to be a trend from the executive branch today to avoid judicial review of a lot of its policies and its actions. And how can the courts and should the courts reassert their duty to act as a check on the political branches?
The question was that there's a trend today by the executive branch to avoid judicial review of its actions, and the question was, how can the judiciary reassert its function as a check on the political branches?
That's panel 3. I was going to say that. Oh, we don't want to answer that hard question. That's an excellent question. And I think that there was one of the Guantanamo-related cases. I can't remember which one now. There was a situation where as soon as it looked like there was going to be review of the cases, then the government sort of shifted around what they were doing with this particular claimant in the case.
Padilla.
Oh, it was the Padilla case. That's exactly right. I'm sorry, I just couldn't think of which one it was.
Padilla, actually.
Yes, Padilla is how he pronounces it. Apparently, that's how he pronounces it.
Okay, that's fine.
I guess he gets to decide, right?
Right.
The government sort of changed his status in an attempt to avoid review, and I remember the Court of Appeals, I think, said, we're going to look at it anyway. You can't come in here and do that to try to avoid, having the courts say what we think about the status of his detention. So I think that, that kind of situation, the courts have actually shown some, inclination to try to not let that happen.
Well, the Supreme Court reversed that decision
Right.
unanimously. No, because usually, you can drop a case if you see the handwriting on the wall. Yeah, of course, the executive branch never likes to be reviewed by the courts. The more important development, I think, is that Congress now, in a couple of recent laws, including the new Military Commissions Act, is barring certain routes of review to the courts, which apparently the Constitution empowers the Congress to do, to limit the jurisdiction of the Supreme Court.
It's panel 3.
Yes, sir.
As the Supreme Court justices age and their acuities become less desirable, they depend more and more on their clerks to reach the ultimate findings that they read. What seems to me is this: at a certain age where they're physically and mentally, their facilities have diminished, they're almost doing a rubber stamp on what their underlings, the clerks come up with. The question I would ask you is this: should there be a limit, an age limit for Supreme Court justices? Because you will admit that at age 85, many of them don't have the mental and physical capacities that they have as young men, and maybe they should voluntarily step down.
So this is Professor Amar has written about this topic. In his book, I heard him speak about this a week or so ago, this very topic that, again, historically, people didn't stay in this position.
Well, and the question, I mean, you suggested two different things. One is, do they voluntarily step down, or one is, should there be an age limit? And, arguably, with improvements in medicine and longer life expectancy, setting an age limit, I think, is problematic. But I've become kind of increasingly open to the argument for a long, finite term for Supreme Court justices, which would still provide the kind of insulation from the political process that is supposed to exist, even if Judge Posner feels that it doesn't really do its job of keeping them from legislating or acting politically. But I do think, rather than an age limit, a fixed finite term of 25 years, I don't know what the arguments are out there, would probably be more suitable.
Yeah, I think that's certainly arguable. If there were a term, the appointing authorities, the president would be less preoccupied with trying to find very young people in order to extend his influence into the indefinite future. The other side of it is, if you have a term, then you're going to have more turnover. And it's so difficult to get these Supreme Court justices nominated and confirmed these days that it's such a distraction for Congress and the president. Not clear you want to increase the number of appointments as you would be doing. You've pointed to something very important, which is actually age independent, which is that the larger and more able the staffs that judges have, the more they are able to hide their incapacities, which may not be age-related at all. Right? So that is a serious problem with the great staff expansion in the Supreme Court and the other courts.
Yes, sir.
This is a question for Judge Posner. Just a minute ago, Judge Posner, you said that in your view, the Constitution permits Congress to withdraw jurisdiction either from the Supreme Court or maybe all courts over constitutional questions. I'm wondering if that was making it up as it goes along, or a legislative judgment, or was it a view of what the Constitution
requires? No, that's in Article 3.
Pardon me?
Article 3 says the Supreme Court shall have jurisdiction with such exceptions and regulations as Congress shall decree.
My point really is that you have just performed what you said that the justices do not do. That is, interpreted the Constitution rather than just making it up as you went along. So it seems to me that it's one or the other. Either the justices make it up as they go along, or they interpret the document.
No, that isn't true, because the Constitution is a set of very heterogeneous provisions. So one provision says, each state shall have 2 senators. Not only is that very definite, but you can also see why you wouldn't want an issue of that sort to be reopened all the time.
Right.
Yeah. But when you get to a provision like the Fourth Amendment, says the people shall be free from unreasonable searches and seizures, then then what you mean by unreasonable, what you mean by search, what you mean by seizure, even what you mean by the people becomes contestable because it's so vague.
But the power of Congress to withdraw jurisdiction is incontestable, I gather.
No, nothing is incontestable because, of course, when Congress tries to do it, then if the Supreme Court doesn't like it, it'll say, well, this was really intended just for, to alleviate the workload of the court and enable it to assign, right? So they could play with it.
So they'd be
In
making
order
it
to-
up. They would be making it up then. which
If
is
they
what
tried
want.
to narrow the exception, that would be an example of judicial discretion, yes.